This is Colin O'Keefe for LXBN TV. The EEOC recently received quite the reprimanding from a U.S. District Court judge for a suit filed against an event management company for its use of criminal background checks in the hiring process. Joining me to explain why they received such a scolding and what that ruling means for employers is Jerry Mattman. He is co-chair of Seifert Shaw's Class Action Practice Group. He is currently lead counsel on 3 of the 5 largest EEOC suits in the country and is editor on the firm's workplace class action blog. Jerry, the judge here really pulled no punches in going after the EEOC for this case here. Can you explain the case a bit and why the EEOC was given such a stern talking to by the judge?
The case is a manifestation of what the EEOC is focused on presently and where its much publicized strategic enforcement plan is aimed. The case was about the use of a hiring screen in judging applicants, and Freeman, the company, used 2 screens. One was a credit check on the theory that people with bad credit would be a risk for fraud or embezzlement of money, and a criminal background check on the theory that those who had been convicted of crimes wouldn't be a safe employee to have around. The EEOC sued on the theory that that sort of hiring screen adversely impacts racial minorities and is not justified by what the EEOC calls business necessity and the ability to perform the job. The case is extraordinary in terms of the result and the language used by the judge in throwing the case out of court. After a few years worth of discovery, Freeman moved for summary judgment on the basis that the EEOC could not prove its case through statistical expert reports of a Dr. Murphy. The judge granted that motion and characterized the expert report used by the EEOC as laughable, filled with errors, and intellectually dishonest. It was one of the more remarkable slapdowns I've seen in 34 years of following these particular types of case where a federal district court judge reacted to the proof brought by the government in support of what had been one of its most high-profile cases throughout the United States.
Wow. So second, what are the implications for employers? How big of a blow does this deal to the EEOC's guidance on criminal background checks?
Well, the case has implications that are wide and varied. The EEOC issued enforcement guidance in April of 2012 saying that we, the government, have interpreted Title VII. This is what we believe it requires employers to do in terms of the use of a hiring screen. That if you use a hiring screen involving criminal background checks, you have to do an individualized assessment of a candidate's criminal history and whether or not they would pose a risk to the workplace. Many people believe the EEOC made that up out of whole cloth. There's nothing in the statute that says that. So the blow in the Freeman case in rejecting the EEOC's theory calls into question of whether or not the EEOC's focus on alleged discriminatory use of hiring checks is something in which the EEOC has a viable theory on which to pursue employers. Immediately before the ruling, the EEOC filed 2 very high-profile cases, one against BMW in South Carolina and one in Illinois against Dollar General on the same theories. Likewise, in January of 2013, the EEOC lost a case called EEOC v. Kaplan, which, much like EEOC v. Freeman, challenged the use of credit checks. So the EEOC is batting 0 if you're looking at it from baseball parlance. They have 2 strikes against them, and so the implications are, will the EEOC amend its enforcement guidance and get out of the business of suing employers? Something else last month that was very extraordinary was when the EEOC filed the lawsuits against BMW and Dollar General, attorney generals from 9 states authored a letter and sent it to the EEOC saying that those lawsuits were misguided and based on a flawed interpretation of the statute. So the confluence of the judge's ruling calling the EEOC's case laughable and intellectually dishonest, coupled with 9 attorney generals challenging the wisdom of the EEOC's lawsuit, tells us that we're in a state of flux and uncertainty as to what the government will do. So I think if you're an employer, you have to keep your eyes on this compliance issue and remember that if you use blanket policies, you're still on the radar screen. But thus far, the EEOC has been unable to convince any judge anywhere of the viability of its theory.
Absolutely. It's an issue for employers to be aware of with the EEOC making this such a priority, but it'll be interesting to see if they continue to bat zero on such cases. Once again, that was Jerry Mattman of Safer Shaw. For more of his insight on this case, be sure to visit workplaceclassaction.com. And of course, if you're not already watching us on LXPN, be sure to visit lxpn.com for more video interviews and curated commentary from the LexBlog Network's more than 8,000 members. Thank you for joining me today, Jerry.
Thank you.